Bill Haywood, Chairman for Fighting for Life in the Ninth.
We're dedicated to educating people about the Freedom of Choice Act. I'll tell you more about that in just a moment. Let me tell you the reason why we're dedicated to this cause. George Washington, the father of our nation, had this to say in his farewell address: "Of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. In vain would that man claim the tribute of patriotism who should labor to subvert these great pillars of human happiness, the firmest props of the duties of men and citizens." Did you hear what George Washington said? True patriots are the individuals who will support religion and morality, and those who seek to undermine religion and morality are not patriots. Our nation desperately needs true patriots who will support religion and morality. Our nation is facing a lot of problems at this time, and there's a lot of differences of opinion as to what is the greatest problem. But I will say to you confidently that the greatest problem facing the United States of America is a moral problem. Yes, we have economic problems and we have security problems, but the front line on all of these things is truth and morality, religion and morality. Consequently, we need to be involved in the business of changing hearts and changing minds, especially when it comes to the issue of abortion. We need to be working to open hearts and open minds so that people will change their mind about this terrible, terrible scourge on America. Our newly elected president, Barack Obama, said on July 17, 2007, when he was still a senator, speaking before the Planned Parenthood Action Fund, "The first thing I would do as president is sign the Freedom of Choice Act. That is the first thing I'd do." Well, the question is, what is the Freedom of Choice Act? It is a bill before both the House of Representatives and the Senate. Actually, it is presently sitting in the Judiciary Committee in the House of Representatives. Let me just share with you a few things from this bill. If you go to our website, www.ffl9.com, there you can click on a link where you can read the entire bill, which is H.R. 1964, called the Freedom of Choice Act. Let me share with you just a few portions from that. Section 4. Now, if this law was enacted, this is what would happen. "It is the policy of the United States that every woman has the fundamental right to choose to bear a child, to terminate a pregnancy prior to fetal viability, or to terminate a pregnancy after fetal viability when necessary to protect the life or health of a woman." Now, you're probably familiar with this terminology, but let me explain a couple of these terms. Pre-viability. It is the idea that the unborn baby cannot live outside the womb. Usually, prior to about 24 weeks, the child has no chance of living outside the womb. Past that period of time, every progressing week, the child has a better chance of living outside the womb. We recognize that we don't live in the dark ages, and many doctors will tell you that this idea of saving the life of the mother is a bogus argument. We have the technology today to try to save 2 lives. There is never a time when we have to murder a baby to save a mother's life. If a baby could live outside the womb, one of the most traumatic things you can do to a woman is to have an abortion. It would be much simpler to have a cesarean section and save both the mother's life and the baby's life. Moving on in Section 4 with the idea of reproductive health, it says in Section B, prohibition of interference, and it says a government may not deny or interfere with a woman's right to choose to bear a child, to terminate a pregnancy prior to viability, or to terminate a pregnancy after viability where termination is necessary to protect the life or health of a woman. Continuing, number 2 under Section 4. A government may not discriminate against the exercise of the rights set forth in paragraph 1 in regulation or provision of benefits, facilities, services, or information. Now let's think about this for just a moment. This is really not difficult, but in the idea of benefits or facilities specifically, religiously affiliated hospitals that receive federal money from Medicaid and Medicare would not be allowed to deny abortion services. As a matter of fact, many of these hospitals would be forced to go out of business unless they did provide abortion services, because if they no longer received their Medicaid and Medicare funding, they would not be able to go on. Also, the idea of services, the idea of providing abortion services, and the idea of information. If a woman goes to her family doctor and says, I want to have an abortion, that doctor would no longer have the right to say, that's against my conscience, I can't help you with that, you'll have to go somewhere else. And you say, well, that's not possible. Well, let's read the next section. Letter C, civil action. An individual aggrieved by a violation of this section may obtain appropriate relief, including relief against a government, in a civil action. In other words, an individual who has the rights denied, if they go to a doctor and they cannot receive the information they want about an abortion, or if they go to a hospital and the hospital refuses to perform an abortion, that individual can sue the doctor or hospital. Now someone might say, well, that explicit language is not within the bill. Well, it's there by implication, and implication is very powerful. Notice what it says, including against a government. What does that mean? If it means including against the government, that means someone else can be sued too. Who's that? Anyone. And so much so that they say, let's suppose that a local municipality says, we will not allow any abortions to be performed within our community. That community can be sued. And also hospitals can be sued, doctors can be sued, anyone can be sued that would interfere with a woman's right to an abortion. Furthermore, notice Section 6, retroactive effect. This act applies to every federal, state, and local statute, ordinance, regulation, administrative order, decision, policy, practice, or other action enacted, adopted, or implemented before, on, or after the date of enactment of this act. In other words, the state of Virginia has no say in abortion services in the state of Virginia if this bill is put into effect. Our particular counties will have no say in this. Our individual towns will have no say in this whatsoever. Folks, this is a major states' rights issue. The federal government will be deciding for us what we will do, and we will have no say in the matter whatsoever. Let me refer you to a couple of summaries. The first one by the Family Research Council. You can go to their website and read this summary. All sides in the abortion fight agree. If FOCA were to pass both chambers of Congress and be signed by a pro-abortion president, it would, among other effects, provide for taxpayer-funded abortion on demand, even late in pregnancy, grant abortionists immunity from legal action, allow abortionists the discretion to perform abortions on minors without notifying a parent, and deny health care workers the right to refuse to make abortion referrals as a matter of conscience. Do you realize how serious a matter this really is? The United States Council of Catholic Bishops had this to say about the Freedom of Choice Act. As a general matter, if FOCA were enacted, it would wipe out a very large number of existing state laws on abortion, substantially impede the ability of states to regulate abortion, and override nearly 40 years of jurisprudential experience on the subject of abortion. Well, right now someone might be saying, well, those are pro-life organizations. Of course they would say those things. Well, let me share with you what the proponents of this bill are saying. Let me share with you what the folks who want this bill to be enacted, where they stand on the subject. Let's go first to the National Organization of Women. And this is on